presentation will be over the case of the Department of Homeland Security versus Regents of the University of California. My opinion of this case is the Department of Homeland Security failed to provide required analysis of all relevant factors associated with ending the program, thus making the agency's decision arbitrary and capricious under the APA. The dissenting opinion was that the administration should be able to resign policies not lawfully implemented. To state it plainly, the Trump administration resigned DACA the same way that the Obama administration created, unilaterally and through a mere memorandum. The federal agencies must follow APA procedures and programs that were not created according to those procedures. But in the dissent, it was argued that the decision creates incentives for outgoing administrations to bind their successors to programs created outside of APA procedures. DHS had determined that DACA was unlawful because the policy was similar to the DAPA and expanded DACA programs blocked by the Fifth Circuit and violating the Title 8 of the United States Code and Administrative Procedure Act. It was also argued that the program DACA was legal, but it just needed to enforce policies reflected in the laws adopted by Congress and should not adopt public policies of non-enforcement of those laws for broad classes and categories of aliens under the guise of prosecutorial discretion. If they would have enforced this and not following the procedures under APA, the program could have been kept and would have been legal. But the U.S. Court of Appeals for the Ninth Circuit rejected the government's motion to dismiss for lack of jurisdiction by law, and there was law to apply. The court knew the plaintiffs had a chance to win on the merits of their arguments, and they would suffer irreparable harm in the absence of preliminary relief. The balance of equities tips in the plaintiff's favor. Moreover, the government wanted the DACA program removed because it was illegal, so to them, the plaintiff failed to distinguish between the DACA program and the DACA, and that they felt why the recession justification differed from the government's own earlier analysis in the Office Counsel Memorandum, which made the program remove later on. After the government resigned the program, there were nearly 700,000 active DACA recipients. They worked and lived in the U.S. communities and contributed to these communities in the same ways that the U.S. citizen and lawful residents do. The reciting of this program made deportation prioritized. They would not automatically be deported, but at one point they would. Since the program was removed, many would have to leave the U.S. and lose everything behind, and lose the chance to ever fix their documents in the future. These were my 3 questions. Did DACA program follow the APA procedures? 2. Was DACA illegal even though it had been up and running for more than 6 years? And number 3. Were the plaintiffs in the wrong, or was the government just trying to get rid of the program for good regarding the situation of the plaintiff?